Greetings, everyone. I'm Frédéric Mégret, co-director of the Center for Human Rights and Legal Pluralism, and I also speak on behalf of my co-director, Professor Nandini Ramanujan, who can't be with us, but will be informed, of course, of how everything proceeds in this meeting. On est ravis de vous accueillir tous. Et particulièrement reconnaissant à la manière dont ce panel a été organisé, c'est-à-dire sur une base bottom-up, where with students, D.C.Ls, local legal actors coming up with suggestions, and that's really one of the ways in which we think the center can be put to good use, is to provide a forum for emerging new ideas and also to confront experiences. And maybe if I just say a word on this, reparations has been a contested topic for a couple of decades now. There's so many ramifications. It's almost become a discipline unto its own, whether it's domestic, international, transnational, human rights, humanitarian, international criminal law, reparations. Unfortunately, this is something on which there is still a lot to say and a lot to be done. But sometimes, as we know, these conversations occur in silos, and people who you would expect to have talked to each other haven't necessarily. And it's just the nature of a lot of research these days that people are sort of pursuing leads that, sometimes geographically or sectorally constrained, with insufficient attention to the fact that, people are working on exactly the same problematique, or at least, a somewhat similar problematique next door. So we're really happy that the center has created this opportunity just through encounters and can help sustain it. And in particular, I would like to add that, I'm really delighted that we can focus on reparations in a comparative perspective, looking at the cases of both Colombia and Canada. And I'm deeply convinced, and I think Nandini is as well, that we need more of these conversations within the Americas. We need more intellectual conversations about these experiences between North and South America. And this is something that has been missing or has been asymmetrical in the past. And we are delighted that we have such a strong contingent year after year of Colombian students in particular doing D.C.Ls. I'm struck by how well represented Colombians are compared to any other, South American nationality at the faculty. And that's been really great. You come with your energy, with your experience, the depth of knowledge that comes from often having confronted head on these difficult questions. And as you know, Canada is itself, locked in a sort of very complex debate over the nature that reparations have and should continue to take in the context of reconciliation with the Indigenous Peoples and First Nations of Canada. So different perspectives in many ways. Colombia obviously dealing with an armed conflict that has lasted several decades. Canada dealing with legacies of colonialism and genocide. But maybe one of the conclusions of this panel will be that these two things are actually closer to each other than meets the eye. So without more ado, I just want to briefly introduce our panelists. The bios have been included in the chat, and in addition, I'm sure they'll tell the audience a little more about how they came to those issues. But we have Maître Éloïse Décoste, who is an S.J.D candidate and legal advisor to the Specific Claims Tribunal, met Marjolaine Olwell. Sorry, I'm doing this wrong. Sorry. Sorry, I thought this was wrong. That's sorry, Trudeau Foundation scholar and L.L.D candidate at UQAM. Now and sorry, it's Marjolaine, who's in Arizona right now, I understand, or at least doing her S.J.D there. And then on the Colombian side, Yuri Alexander Romaña-Rivas, who's in the early stages of a really interesting project on reparations in Colombia, particularly for Afro-Colombians, and Laura Baron-Mendoza, my own D.C.L candidate, delighted to supervise Laura, who has a very strong interest in the conflict and the transition in Colombia and the role of armed groups in generating norms of governance, but also reparations and reconciliation. I will leave it there and open the conversation. Open the floor. The idea is that there will be presentations by each of our panelists. And we're very much looking forward to this being a conversation and leading up to questions and exchanges. Thank you very much all for being present. Éloïse, à toi la parole.
D'accord, merci, Professor Mégret. Thank you as well to the Center of Human Rights and Legal Pluralism for hosting this event. It's great to be back at McGill, albeit virtually. So we all know that Canada has an unresolved history of violation of Indigenous peoples' rights. Over the past decades, Indigenous demands for true justice, accountability, reparations, and decolonization have amplified. In response, a series of truth-seeking bodies have been established, from the Royal Commission in the 1990s all the way to the Truth and Reconciliation Commission and the National Inquiry into Missing and Murdered Indigenous Women and Girls in recent years. And all of these inquiries have reported on the blatant, repeated, deeply rooted, and ongoing violation of Indigenous peoples' rights. Yet, few of their recommendations have been implemented to this day. Meanwhile, the dire consequences of settler colonialism continue in Indigenous nations, and Indigenous erasure and dispossession is ongoing. So while reconciliation has emerged in recent years in official discourse as the new paradigm for the transformation of the relationship between Indigenous peoples and the state, what it means is ambiguous and vividly contested. So my presentation today will seek to contribute to the conversation on how the state must respond to this troubled history by addressing some of the legal questions about the state's obligation to provide reparation under international law. So let me start quickly with the legal framework. So as early as 1928, the Permanent Court of International Justice described the duty to provide reparation as an indispensable complement of any breach of an international engagement. Now, many decades later, the International Law Commission sought to codify these customary norms into a document that's known as the Draft Articles on the Responsibility of States for Internationally Wrongful Act, which in 2001 was annexed to a UN General Assembly resolution. So what this document tells us, essentially, is that when a conduct that can be attributed to a state, so either an action or an omission, constitute a breach of an international obligation, either customary or conventional, it triggers that state's international responsibility, and as such, brings about four main legal consequences, namely that the state must perform the breached obligation, must cease the wrongful act, must provide adequate insurances and guarantees of non-repetition, and must make full reparation for the injury caused in the form of restitution, compensation, and satisfaction. Now, historically, international law was focused on interstate relationship, but the emergence of the International Human Rights Law regime has brought about a change in paradigm whereby states are now bound with obligations towards individuals under their jurisdiction. And international human rights law treaty do recognize a right to reparation for victims of human rights violation. Some treaties recognize that right explicitly, and where it's not explicit in the text of the treaty, it's considered to be part of the state's general obligation to respect, protect, and fulfill human rights. It's noteworthy in this regard that the draft articles recognize that an international obligation can be owed to one or many states or to the international community as a whole. Now, the language here is important because early treaties used to have the language international community of states. And so by using the international community as a whole, it ends to an inclusion of non-state actors. More or less in its commentaries on the article, the International Law Commission makes a distinction between the injured states and the beneficiary of the duty to provide reparation. Now, in the case of multilateral treaty, like human rights treaty, the injured states are all the state party to that treaty. But the beneficiary of the duty to provide reparation will be the individual who have been injured by the breach. So the International Court of Justice actually embraced this distinction and this approach in the 2004 advisory opinion on the construction of a wall in the occupied Palestinian territory. Also, the Inter-American Court of Human Rights has used this approach in the Plan de Sanchez case, notably. So in sum, what we can understand here is that under international law, if a state breach an international duty, it has an obligation to provide reparation, and this obligation might be towards other states or might be towards individual groups or perhaps a people. So what does this mean for Indigenous peoples? Well, as I just explained, for the state's responsibility to be triggered, an international obligation must be breached, which means that the obligation must have existed at the time of the wrongful act. Now, given the principle of non-retroactivity of international human rights law treaty, the temporal scope of the duty to provide reparation is restricted. So it's generally said that an historical injustice, namely one that happened before the emergence of international human rights law, will be beyond the purview of the state's obligation to provide reparation. So consequently, Indigenous grievances, particularly as they pertain to land dispossession, denial of sovereignty, position of assimilationist policies, are commonly described as being historical injustices, and as such are accepted as morally reprehensible by virtue of today's standards, but are said that they don't give rise to a duty to provide reparation on the state, unless evidently a breach of an existing obligation at the time of the act can be shown, which is rare because, as we know, law has been a prime tool of settler colonialism. So in other words, reparation, according to this view, reparation for Indigenous grievances is contingent upon political will, which is often lacking in settler state. Now, in my opinion, this characterization of Indigenous grievances is erroneous. Here's why. Well, there are many features that distinguish Indigenous grievances from other types of so-called historical injustices. But most importantly, Indigenous demands for justice and reparation are not strictly historical. As shown by all this truth-seeking body, today's violations are a product of settler colonialism, which we need to understand as the state's deliberate effort to make Indigenous people as political entity disappear because they constitute a threat to the Crown's claim to sovereignty and to land. And settler colonialism is still alive and well in Canada today. It's still an integral part of our constitutional and legislative structure. At the time of Confederation in 1867, Indigenous people were not made active participant in the new federation. They were rather relegated to object of federal legislative power. And that constitutional structure is still in place today. Yes, in 1982, Indigenous rights were enshrined into the Constitution, but the interpretation of those rights have fallen short of any form of recognition of sovereignty and have been described by many as an empty box. Moreover, the Indian Act, which was a prime tool used to fragment indigenous nations into small bands to impose a unilateral definition of who is considered an Indian in the eyes of the law, and which was a tool used to repress any form of governance, cultural, linguistic practices of indigenous people, well, is still in place today. Yes, some of its most repressive provisions have been removed throughout history, but its underlying logic of assimilation continues. So in short, indigenous people have not suffered injustice at a specific time in history, like, let's say, Japanese Canadians during the Second World War, who were interned during the Second World War, but rather have suffered a constant and persistent flow of injustices from the earliest day of colonization to the present, and it's ongoing. And in that sense, I think we need to understand Indigenous grievances not merely as historical, but rather as continuing. And why is that characterization important? Well, because under the law of state responsibility, continuing the wrongful acts, namely those acts that happened prior to the emergence of a norm bounding that state, but have continued thereafter, will also trigger an obligation to provide reparation. Let me give here quickly two examples of this. So the first one is enforced disappearance. If a person disappears prior to, let's say, the ratification of the relevant treaty by the state, but his or her fate remains unknown after the state ratified that treaty, the violation will be continuing and will trigger state obligation until the fate of the disappeared is known. Another case that's really interesting and that's discussed in the commentaries on the draft articles is that of expropriation. So the International Law Commission in its commentary makes a distinction between lawful and an unlawful expropriation. And in the case of an unlawful expropriation, even if it happens before the emergence of the relevant human rights norm for binding that state, it will be considered a continuing violation until the expropriation ceases. And I think without going into detail, because I see time is going fast, I think there's a very interesting analogy here to be made or to be thought through with regards to land dispossession for Indigenous peoples. Now, it's also noteworthy that the UN Human Rights Committee in the Lovelace case used the notion of continuing wrongful act to find Canada in breach of the International Covenant on Civil and Political Rights, even though in that case, the original situation happened before the Canada ratified the treaty. So briefly, Sandra Lovelace was a Maliseet woman who had lost her status under the Indian Act through marriage to a non-status man. And when she sought to return to her community, she could not do so because of lack of status. Now, even though she was discriminated in the sense that she lost her status prior to the ratification of the covenant by Canada, the Human Rights Committee found that this had triggered continuing violations that were ongoing, and it's based on this that they found a violation of the ICCPR. Now, I think there's here again an analogy that can be made to the ongoing violation that results from many of the assimilationist policies that have been imposed throughout the years. So therefore, by virtue of settler colonialism's structural nature and its ongoing existence within the state's architecture, I suggest that it constitutes a continuing wrongful act and as such triggers an obligation for Canada to provide reparations for Indigenous people. Now, it's one thing to find the existence of that obligation, which I think remains by and large unfulfilled. But then this gives rise to a series of other questions. What constitutes full, effective, and adequate reparation for settler colonialism? How should reparation be designed? Should they be granted to individuals, to collective, to nations? And most importantly, why do reparations matter? Can reparation or what role can reparation play, if any, in social transformation and decolonization? So I will stop here and I will turn to my colleague who will address different aspects of this question by looking at the practice of reparation in Canada and in Colombia. Thank you.
So thank you so much for having me today. I really appreciate you all being here to listen to us speak on such an important topic, which is reparations. My sort of role today, or my objective today, is to focus rather on a more practical example of how reparations for historical wrongdoings and human rights violations can and have been set in place in the Canadian context. So Canada has set in place a few reparation processes over the past decades. Now, a few examples of these can be, for instance, the Indian Residential School Settlement Agreement, which I'll be discussing in more detail, the Day Scholars Settlement Agreement, which followed it, the Specific Claims Tribunal Act, which is not a settlement, but is the result of an agreement between First Nations and the Canadian government, and does constitute a form of reparation, or even the most recent agreement in principle on long-term reform of the First Nations Child and Family Services Program and its principles, right? So there's a fair amount of these interesting reparation processes. Right now, I'm hoping to get to speak with some detail on the Indian Residential School Settlements Agreement. And if I have the time, I'll discuss a bit the Specific Claims Tribunal, although I'm not sure I'll have enough time. So please, during the question period, don't hesitate if you have some questions on the Specific Claims Tribunal. I'd be happy to answer those. So although I suspect, and well, I hope that most of you know this, here's a quick overview, especially knowing that there's a lot of students from Colombia and surely from many other countries, on what Indian residential schools were. So it's very important to understand these were government-funded but church-run schools that were set in place as part of a coherent policy which aimed to eliminate Aboriginal people in Canada as distinct people and assimilate them into the Canadian mainstream. The residential schools were opened from the moment Canada became a country, as of 1867, becoming widespread as of the 1880s, and quickly became a central element in the federal government's Aboriginal policy. These schools received more than 150,000 First Nations, Métis, and Inuit children against their parents' will, and their existence spanned for over 100 years, last school being closed in 1996. It's important to mention that students were prohibited from speaking their own languages, from practicing their cultural traditions. They were separated from their children, prohibited from speaking to each other, and children were mistreated. They were provided with neither proper education, nutrition, healthcare. They were physically disciplined on a daily basis, and neglect was common. Physical abuse and sexual abuse was also rampant. So many children came back to their communities with serious psychological issues, and many reproduced behaviors that they had been subjected themselves to. And so residential schools can be said to have had impacts that transcend generations and cause intergenerational trauma, and to have contributed to social problems that continue to exist to this day. So how did we get to this agreement? Although I don't have the time to get into the details on the history of the negotiations leading to the agreement, which are quite interesting, I recommend reading on it, I think suffice it to say that what happened at residential schools remained mostly a secret until the early 1990s, when Phil Fontaine, who at the time was the Assembly of Manitoba Chiefs leader, and later on the chief of the Assembly of First Nations, when he came out and publicly stated that he had been abused in residential schools, and that he was convinced that he wasn't alone suffering from this, and started encouraging people or others to speak out. This began a floodgate of lawsuits, and finally victims came together and constituted a large class action against the federal government as well as the religious entities that were operating the schools. And the government was at that point forced to negotiate or to seek a negotiated resolution of the matter. Now, despite many issues and setbacks in the setting up of this alternative dispute resolution system that were suggested by the government, a first failed apology. Thanks to the leadership of the Assembly of First Nations, its chiefs, and its chief negotiator, Kathleen Mahoney, the parties were finally able to come together to negotiate an agreement on satisfactory terms. And the final settlement agreement was signed on November 5th, 2005. So what are the components of this biggest at the time settlement in Canadian history? Well, first off, a part of the settlement agreement is an apology on June 11th, 2008 from Prime Minister Stephen Harper, recognizing Canada's responsibility and formally apologizing in the House of Commons for the intergenerational trauma that was caused to Indigenous peoples. Now, the Indian Residential School Settlement Agreement also had four specific components. A common experience payment, which provided for an initial compensation of $10,000 for the first year of attendance of all students in a residential school, to which an additional amount was added for each additional year of attendance of the children in these schools. Now, why is this important in the context of the conversation about reparations? Essentially, this first common experience payment acknowledged the trauma that was associated with forcibly taking children from their communities and sending them to school in a school whose objective was to assimilate children, and which also acknowledge their mistreatment, their neglect, and the physical discipline imposed on these students, or the horrid conditions to which they were subjected. Now, a second component of this independent assessment process, I just think quickly, this common experience payment, to tie into what Éloïse was saying earlier on, is also quite interesting, because although assimilation was not part, or was not necessarily a crime at the time, there was a recognition of the horror of what that constituted, right? And so that was included into the settlement agreement. It couldn't have only, the settlement agreement couldn't only have compensated victims of sexual abuse, for instance, or physical abuse. But there was also an additional chapter, which is what we call the independent assessment process. So component number 2, or the IAP, I'll be referring to it as the IAP. And this process was a non-accusatory alternative dispute resolution process, which was set up to compensate specifically sexual and severe physical assaults that were arising from or connected to the operation of an Indian residential school, whether or not occurring on the premises or during the school year, committed by adult employees of the government or a church entity which operated the IRS in question, or other adults lawfully on the premises. So still a pretty large scope to this IAP. Student-on-student sexual and physical assaults were also compensated within some with some limitations, but the nature of the conversation today doesn't allow me to go further into details. And other wrongful acts were also, which was generally a severe physical violence, were also compensated. So what was unique about this process was that it was conceived to avoid, as much as possible, any kind of re-victimization of survivors. So the process was held in the communities or not, at the request of the survivor, in order to ensure their confidentiality. If they preferred it being in the community for the support system, they could. If they wanted to go to the nearest city, that was also possible. The proceedings were a roundtable proceeding, so it was far from a courtroom setting, right? They didn't seek to be this sort of intimidating setting, which is what the first survivors to have come out and denounced the sexual abuse that they'd been subjected to had to confront, right? Going to court and being cross-examined on the abuse that they'd sustained. So we're not reproducing that within the IAP. The process began with a prayer or an opening ceremony. There was an eagle feather or option or a Bible swearing in process. There was cultural competency training for the adjudicators. There was also, and I think this is very important, a lowered burden of proof. So rather than unusual sort of civil proceedings, which would require that the events be demonstrated on the balance of probabilities, pardon me, what was required was that the evidence be credible and reliable. There was also a mandatory disclosing of all of the records and supporting evidence by the government, the RCMP, presence of social workers or elders for emotional support, and a personal apology. Now, compensation was awarded for the acts that were proven to have taken place, the harm that these acts had caused in the victim's life as a result, aggravating factors, and this compensation, or these heads of compensation, could allow to go and obtain up to $250,000. Now, loss of opportunity or an actual loss of income as a result of this. So, for instance, if a survivor had drug dependency afterwards and lost his jobs or had struggled throughout his life with issues and which impacted their opportunities or their generated an actual income loss, there was a possibility to go get $275,000 additionally there. And then there was a component which was called the Future Care Plan that allowed for $10,000 of therapy, of money going towards a therapy of some kind, or counseling, I should say. So now the third component of this settlement is the Truth and Reconciliation Commission. The TRC traveled across Canada or across the country for around 6 years, gathered the stories of survivors, documented a lot of history behind each residential school. And this is important because this is part of truth, right? The gathering of truth, which is so integral to the concept of reparations. And the TRC published an important final report in which it concluded to a cultural genocide and provided for an important roadmap to address the root causes of the problem and avoid their repetition. So, and finally, the Aboriginal Healing Foundation, this is the fourth component, which provided a 24-hour hotline to support survivors while they revisited their traumatic experiences in order to participate in the settlement agreement and the IAP process, right? So throughout the entire process where survivors were going to these hearings, there was support. Now, in no way do I want to seem like I'm saying that the agreement was perfect. I'm speaking about the construction of the agreement. And this was one of a kind and something new, but I think there is definitely something we can learn from this. So what were the problems with the Indian Residential School Settlement Agreement? The exclusion of many survivors of day schools, abuses, or of some abuses that took place outside of schools, some bad faith of attorneys for Canada in their approach to these claims, their attitude sometimes that the government was being too kind or giving too much, the lack of cultural competency training of adjudicators, some bad faith in disclosure of files, and then at times the lack of criminal prosecutions for offenders or sexual offenders, right? Although this at times was considered to be an advantage because it encouraged further disclosure. It also didn't cover intergenerational trauma. So children of people who had been affected by residential schools and affected by the actions or the trauma of their parents didn't also get to be repaired. It generally embodies the international requirements for reparations structure. There's a compensation, right? When restitution in integrum, as they call it, is not possible, such as in these circumstances, a fair compensation will be granted for moral and material prejudice suffered to the victims for their loss of revenue. There's rehabilitation that's been included into the process. And although the Aboriginal Healing Foundation didn't go far enough in the support that they gave and the counseling that they gave to First Nations, because there was a time frame or time limit, the agreement didn't contain a certain form of rehabilitation. There was satisfaction measures. So these are non-pecuniary compensation measures that are usually granted when the dignity of a person is affected. So here the formal apology of the House of Commons by the Prime Minister was very important. There was a personalized letter of apology to IP survivors, which was very meaningful to some survivors. And then finally, non-repetition measures. So the TRC calls to actions really addressed a variety of fields in which action needed to be taken, from health services to schools to the legal professions to universities, etc. And so I know that in the interest of time, I should probably stop right here. I've already gone over, but I really appreciate you all listening to me, and please don't hesitate to ask some more questions. Thank you.
It's your turn, Yuri, and we switch to the Colombian side of things.
Exactly. Now we're going to discuss a little bit of Colombia. So good afternoon, everybody. Thank you for having me here this important event. As you can imagine, discussing the reparation structure for victims of the Colombian armed conflict is a topic on which one can spend hours. Still, I will do my best to share with you what I think are some essential ideas about this topic in 10 minutes. Hopefully, during the Q&A section, we will be able to continue deepening the discussion based on specific questions or comments. I have titled my presentation, A Brief Contextual History and Evolution of the Colombian Reparation Structure. In this respect, I would like to tackle two important aspects. First, I will share with you some background information about the Colombian armed conflict and the evolution of the reparation policies in Colombia. And second, I will discuss the 2011 Victims Law, which established the broader legal framework for reparation of victims in Colombia. With respect to the first aspect, Colombian society has been the victim of more than 50 years of armed conflict. Different armed groups have participated, ranging from armed guerrilla organizations that identify themselves with left-wing ideology to paramilitary armed forces that identified themselves with right-wing ideology. As a result of this protracted violence, there are more than 9 million victims of the armed conflict. Approximately 220,000 people have been killed, and more than 81% of those killed have been civilians who were not taking direct part in hostilities. Now, it was until 1997 that the Colombian government started to adopt measures to compensate some victims of the armed conflict, particularly internally displaced persons, and encourage the mobilization of members of illegal armed groups. However, when massive waves of internally displaced persons from rural areas to urban centers started to take place between the late 90s and the early 2000s, the Colombian government started to treat them as internal migrants and not necessarily as victims of the armed conflict. Many of these internally displaced persons began to file with courts legal requests for the protection of their constitutional rights, something that in Colombia we call acciones de tutela or injunctions, to ask for help from government institutions, and that receive support in the form of food, medical care, and shelter. The Colombian Constitutional Court reviewed many of these legal requests and established a structural problem that required a structural solution by the state. As a result, in 2004, the Constitutional Court rendered a historical decision. The decision T025, which is an acción de tutela, basically. Through this decision, the Constitutional Court asked the Colombian state to adopt structural measures to address the systemic challenges facing internally displaced persons. This ruling highlighted the precarious situation that internally displaced persons were undergoing as victims of the armed conflict. It forced the state to mobilize resources and institutions to offer solutions to these victims. The Social Network Agency was the Colombian institution tasked with leading this effort. Nonetheless, those efforts were not enough. In 2009, the Constitutional Court issued other rulings asking the Colombian state to guarantee the rights of internally displaced persons, particularly indigenous and Black communities, including the right to return safely to their territories of origin. As another contextual element, it is essential to remember that in 2005, the Colombian government and the right-wing paramilitary armed forces reached a peace agreement. This agreement was enshrined in Law 975 of 2005, or the Justice and Peace Law. This law is relevant because it established a reparation structure in which victims in which victim reparation was mainly contingent on the economic capacity of the perpetrator of crimes. In other words, there was no state obligation to compensate victims. And of course, many perpetrators alleged not to have economic means to compensate their victims. Therefore, victims of paramilitary armed forces were left in a precarious situation to obtain or have access to reparations. In 2010, as a part of the strategy to persuade the guerrilla of the Revolutionary Armed Forces of Colombia, FARC-EP, the oldest and strongest guerrilla armed organization in the country, to negotiate peace with the government, the then President Juan Manuel Santos administration undertook efforts to establish a broader legal framework for the reparation of victims as a state obligation. As a result, the Colombian government adopted Law 1448 of 2011, or Victims Law. This allows me to move on to the second point of my presentation, a brief discussion of the said Law 1448 of 2011, or the Victims Law. This law mandated the creation of the National System for Victims' Attention. This system is composed of four main components or elements. The first, Unit for Victims' Attention. Second, Unit for Land Restitution to Victims. Third, the Agrarian Tribunal for Land Restitution. And fourth, the Center for Historical Memory. I will briefly discuss each one of these institutions as follows. First, the Unit for Victims' Attention is in charge of the administrative reparation of victims. Victims of the armed conflict can ask for administrative monetary compensation from the government. In this respect, this unit has a list of the different crimes and violations that have taken place during the armed conflict. And there is a monetary amount allocated for each type of crime or violation. According to this, the victims can be offered an X amount of money as administrative reparation, and the victims can decide if they accept it or not. If they choose not to accept the offer of administrative compensation, they can go and sue before the courts to obtain the reparation they consider they deserve. But what could the problem with going to courts be? This option challenge is that legal proceedings can take a fair amount of time to conclude. Additionally, this unit coordinates and leads the strategic plan for victims. This unit has offices throughout the country as well. Second, the Unit for Land Restitution to Victims has the role of representing victims' land restitution claims that argue that they were displaced from their lands or illegally dispossessed. These land claims are litigated before the Agrarian Tribunal for Land Restitution, where they can seek to obtain their lands back or be offered lands of the same quality and size. Third, the Agrarian Tribunal for Land Restitution are tasked with adjudicating land restitution claims by victims. This is relevant because one of the structural causes of violence in Colombia is land concentration ownership on the hands of few, and land dispossession of peasants and rural communities. Four, the Center for Historical Memory has the monumental role of documenting the truth of the armed conflict and presenting it to the Colombian society comprehensively. They have pushed different, they have published different reports on different aspects of the armed conflict, such as massacre against the civilian population, for disappearance, and the roles of different armed actors in the context of the armed conflict, of course. Now, what are the contributions and challenges of the reparation structure? The reparation scheme has been hailed as an improved and more comprehensive reparation structure compared with what Colombia had in the past. In this reparation structure, a clear state duty has been established to grant reparation to victims of the armed conflict, regardless of the perpetrators and their economic capacities. And an important step has been taken to redress the land dispossession of victims of the armed conflict as well. However, challenges remain to be addressed. For example, the fact that the law only allows for land restitution to victims going back to 1981 is problematic because land dispossession as a result of the armed conflict has been taking place before 1981. Additionally, it has been underscored that land restitution to victims falls short of what is necessary to address excessive land concentration in the country. Therefore, it has been argued that more structural measures are required to grapple with that issue that has been the genesis of violence in Colombia. Another challenge is that out of the 9 million victims, fewer than a million have received some form of reparation so far. According to some statistical information, at the current pace, it would take until 2065 for the Colombian state to offer reparations to all victims of the armed conflict. Consequently, the system needs to be readjusted to provide timely reparations to victims. Another challenge the system faces is to offer adequate collective reparation to indigenous and Black communities. In this respect, it is worth highlighting that the collective reparation plans have been slow to be adopted and implemented in the territories of these communities. But a crucial question remains. Does the Colombian broader reparation structure have a more restorative and individualist approach to reparation of victims, or does it have a more transformative and collective approach to reparation? The answer is not simple. Even though the Colombian reparation legal framework makes reference to a transformative aspiration of reparation measures, and the reparation scheme does have the potential to achieve social transformation, the truth is that in practice, there has been a piecemeal approach to reparations, meaning that through the lens of restorative or corrective justice framework, a more targeted individualistic approach has driven reparation for past violations or wrongdoings against identified individuals or communities. As my colleague Laura Baron-Mendoza will share with you later on, in 2016, the Colombian government and the former guerrilla of the FARC-EP reached a peace agreement that has given rise to a new legal and institutional framework for the reparation of victims, which is meant to complement the already existing institutional framework. I will give the floor to Laura, and I'm looking forward to your questions and comments during the Q&A section, so we can continue deepening our discussion on this topic. Thank you.
Well, good afternoon to all of you. I'm afraid that there's too many questions to answer, and I'm going to put more questions on the table. So just to following what Yuri was saying, I would like just to mention one thing to share with you, and is the dimension of the reparation task that we have in Colombia. In Colombia, there's more than 9 million victims of the armed conflict that have been registered. This figure corresponds to approximately 17% of the total population in Colombia. In other words, out of every 10 Colombians, almost 2 people have suffered direct victimization during the country's armed conflict. And additionally, the enormous underreporting must be considered, since many people do not feel safe at all, recognizing themselves as victims, or they do not trust the institutions, or they have decided to try to forget what happened, or they simply cannot be included in the registry, given the procedure and the requirements of the entity that is in charge. So as you could see with Yuri's presentation, Colombia has almost 10 years of experience in the formulation and implementation of transitional justice mechanisms. And between 2005 and today, different laws have been issued, public policies have been formulated, and transitional justice mechanisms have been put in place, both for criminal justice and accountability of ex-combatants, as well as for clarifying the truth and building no judicial memory and reparation to the victims. So now, this being said, with the signing of the peace agreement with the FARC in 2016 that Yuri also mentioned, and the launch of the Special Jurisdiction for Peace, which is the justice component of the transitional justice system, many victims have wondered how the mechanisms that the agreement incorporates will contribute to guaranteeing the access to what we have called comprehensive reparation. And this looks kind of like an obvious question, but not so obvious when people started to ask about how were the ex-FARC combatants going to contribute to victims' reparation? With money, as other armed groups had done before? So the final peace agreement actually, with the FARC, one of the several armed actors that we have in Colombia, has 6 points. Number 5 refers to the victims and the rights, including the reparation. So I'm going briefly to show you the mechanisms created under this point to guarantee victims' right to reparation by highlighting how ex-combatants are asked to repair by being part of those mechanisms. And even though we're still learning on the way, well, I think that there's a lot of progress. And well, this is something that we're developing day by day, and it started a few years ago, and we still have a long way to go. So we know that Éloïse has talked about the state's obligation to repair, and that based on the treaty language, we could include armed actors. But how do we address that? In Colombia, the roles of ex-combatants to guarantee victims' reparation can be seen as, I would say, the sanction, as one of the several steps of their reincorporation process, or even as part of reconciliation efforts. So there are lots of perspectives that we can just have here to analyze the role of ex-combatants. So I'm gonna stop sharing my screen with you so you don't have to see my face the whole time. Just give me a sec. There we go. So basically the point 5 of the agreement creates a comprehensive system of truth, justice, reparation, and no repetition, which is composed by 5 mechanisms. I'm just gonna put the emphasis on 2, the comprehensive measure or reparation measures and the special jurisdiction for peace. And just to say that the reparation measures that are included in this comprehensive system include as well the ex-combatants, and they include specifically 8 different measures, in which 3 require the direct participation of ex-combatants that are reflected in the other components of the system. So as something that I have to say is that each component of the system fulfills the satisfaction of a right, but all the components must protect the set of rights of the victims, especially the reparations. So I'm just putting here 3 of those reparation measures that include ex-combatants. The first one are the early acts of recognition of collective responsibility. And here we have different examples. I'm just showing here some pictures. The one is the truth that the ex-combatants have to share when they are in a judicial process as such. So before the special jurisdiction for peace. 2, the truth that they have to share, their narrative, their version of the truth that they have to share before the Truth Commission. And we have various acknowledgement and pardon meetings that have been held in the country. One of the most representative was a reconciliation meeting in June 2021 held between the FARC and kidnapping victims, in which the former guerrilla group acknowledged its responsibility for the kidnappings perpetrated in the conflict, and they also asked the victims for forgiveness. So here's a picture, but I will also share with you a link if you want to watch the meeting they had, although it is only in Spanish. The second measure is the concrete actions to contribute to reparation. And here is that the FARC will have to participate in reparation actions such as infrastructure reconstruction, humanitarian demining, search for and location of disappeared persons, as well as eradication of illicit crops. And a specific example is the creation of the Commission for the Search of the Disappeared. This commission belongs to the Communist Party, which is the political party that replaced the extinct FARC. And they collaborate with the unit for the search of persons reported as disappeared. Their function is to document cases of possible disappearances, then seek the information with other ex-combatants who might have participated in operations in which the disappearances occurred. So far, they have documented more than 800 victims, if I'm not mistaken, of which more than 100 have been located already. And this information has been delivered to the unit, as well as to the International Committee of the Red Cross, so that they can proceed to the exhumations. And the third one is the commitment of the FARC to contribute to comprehensive reparation. And yes, this is vague, but this is in regard of the money, the assets, the belongings of the FARC. Those are, the agreement also address the transfer of FARC's goods, belongings for reparation to the victims of the conflict. So for this, what we did is that we did an inventory in 2017, and the deadline for the delivery of those assets, goods, belongings, or whatever was in December 31, 2020. So what has been delivered actually is equivalent to only 4% of the total initially inventory. That, without a doubt, poses a ton of questions and critiques. But these three examples can be part of what we call works and activities able to repair and restore, and we will focus on them in a couple of minutes. I just want to go back to the system and focus on the special jurisdiction for peace, and here is why. The point is that regarding the HEP, even though the special jurisdiction for peace, and I'm saying that in Spanish, which is HEP, is the justice component, it is also in charge of ensuring the rights to truth, reparation, and non-repetition. The HEP must ensure that sufficient and adequate reparation is given to the victims within its sphere of competence. So one of the guiding paradigms of this jurisdiction is restorative justice, which is understood as a model that, instead of focusing on punishment, focuses on repairing the damage caused to people, restoring the relationships that have been affected as a result of the crime, and reintegrate the offender, which is really new in our legal language. It preferably seeks the restoration of the damage caused, specifically to put an end on the situation of social exclusion that has caused the violations of the rights, their suffering. And in terms of what you were saying, Éloïse, is how we can actually confront, for example, colonialism, and racism through reparation. So how does the HEP involve those responsible for the crimes in guaranteeing the right to reparation? In Colombia, all the individuals over whom the HEP has jurisdiction, including ex-FARC, and who aspire to receive criminal benefits, will have to comply with the duties of contributing to the truth, acknowledging responsibility, contribute to the reparation of the victims, and guarantee the non-repetition. And this scheme of benefits and conditions is called the Conditionality Regime. And in order to comply with the objectives of that system, those individuals may carry out works and activities able to repair and restore, which we call in Spanish, TOR. And I'm going to refer to that in Spanish because it is easier. So it's TOR. And here we have two kinds of TORs: in advance of sanctions, which means that they are proposed and carried out voluntarily by ex-combatants, or as part of the proper sanctions that the Tribunal for Peace will establish upon them. So both figures are part of the conditionality regime. And just to clarify who can perform a TOR, is that they can be carried out by people over whom the HEP has jurisdiction. That is to say, ex-combatants of the FARC-EP, members or ex-members of the public force who have committed crimes in the context of the conflict, state agents also who are not members of the public force, and also civilians who have participated in acts of the same nature. All of them, they must participate directly and actively in the execution of the TORs. It is not possible to delegate its implementation to other people, and that is important. And one of the purposes of the TOR is the satisfaction of the rights of the victims with a restorative justice approach. But yes, this is too vague. And it's a question that we keep asking is, what does the restorative character of the TOR really refer to? And the way to answer to it is by allowing the interested parties, that means the victims and the communities they live in, to do so through mechanisms that ensure the dialogue with the HEP itself, but also with the ex-combatants directly. And this is why the TOR must guarantee the effective participation of the victims. So besides I think that towards do not necessarily have the calling of individual reparation that Yuri was referring to at the beginning for each and every one of the damages suffered by the victims. The type of reparation compared to what Yuri was explaining, the type of reparation targeted by TOAR as part of the conditionality regime in Colombia works with measures of another order. These are measures that have more collective nature, since they seek to respond to the damage of the social fabric, while at the same time they can, although not necessarily, impact individual victims and their family. This means that the repair of the social fabric based on the experiences of the communities and the cultural tradition is perhaps one of the central objectives of the restorative component of the TOAR. And this does not prevent the TOARs from having a reparation effect in some individual dimensions. And based on the principle of comprehensiveness, all the points in the agreement, particularly the reparation component, must be articulated whenever possible with other programs and mechanisms of the agreement. That includes the administrative reparation mentioned by Yuri, or the activities of the reintegration process. And here I want really to make an emphasis here, because the final agreement clarifies that access to reintegration measures requires a commitment of responsibility with the agreement and their goals. And it is established that former members of the FARC are required, within the framework of the process of reincorporation into civilian life, to carry out actions that contribute to the reparation of the damage caused, considering the need to comply with and satisfy the rights of victims as an integral part of the peace building process. And I think that I've talked a lot, but I just want to finish with saying that this is one of the most crucial points and added values of this agreement. We're saying that for the ex-combatants to be successfully incorporated in civilian life, they do have to perform acts of reparation. So even if they are not called before the HEP, the Special Jurisdiction for Peace, for the commission of crimes and human rights violations, they do need to be part of these efforts. Why? Why do you think they need to be part of these efforts? And I'm gonna stop sharing this. Sorry, I was not counting the time, but Sharon, do I have more time? Or exit?
Frédéric tell you that, but I think that's more or less the time to leave for questions and answers.
But yeah, it is just to say that that is the most amazing added value of this agreement. And this allows us to understand also the meaning and the scope of the comprehensive system as a whole, articulated by conditionality. And I'm going to stop there. I have some examples of how the experts have started to participate in reconciliation acts and different acts, but I'm going to stop there. So
okay. Okay, no problem. No, that was great. Look, thanks to all four panelists. I think there's just a huge amount of richness, but I'm looking forward to the questions to see how it comes together. So the floor is basically open. You can raise your virtual hand or just wave if your camera is on, you know, or agitate in whatever way you prefer. That's just me giving you time to think about your questions. I mean, I could throw in a question just so everyone sort of gathers their thoughts. So one thing that strikes me is there's a lot of thinking that goes into what kinds of reparations should be paid. And everyone, and that's, you know, I wouldn't say the easy part, of course, but that's the sort of tempting part. I mean, it's, you know, one wants to give reparations and, you know, to give reparations that are just. I'm always a bit concerned by who pays for reparations and what, you know, what happens if people, you know, have caused much more harm than they can compensate for, right? And how do you provision for this? And you know, who kind of steps in potentially to guarantee that reparations are paid when, you know, maybe individuals can't pay them? That's, yeah, at least if we're talking in monetary terms. I mean, you know, no one can apologize for you, right? So the apology you can do, but anything that involves paying reparations. This is a problem that we've encountered at the International Criminal Court, where people get these huge awards, or in ATCA litigation, right? So you have these huge awards against people who then have no money to pay for it. And I guess the problem is reparations often still seems like it's based on a very kind of tortious extra-contractual model of responsibility, where it's the person who did harm or the agent who did harm that most directly that has to compensate, but that doesn't always account for the fact that harms are very structural sometimes, and have been caused by the coordinated or uncoordinated acts of a variety of factors. Anyhow, so that's who pays is my question. If anyone wants to sort of shed light on that.
I can go. I think that Professor Mégret, your question is very interesting, because I think it goes to the core of the debate about reparations. And I think there are several layers of analysis, and I think reparation need to be seen like a combination of forms of reparation. It doesn't need to be seen like one or another. So, and I'm going to give a very concrete example just to illustrate what I mean. There was this municipality in Chocó, Bojayá, that in 2002 was victim to a was subjected to a military confrontation between paramilitaries and guerrilla armed groups. And as a result, they launched a cylinder bomb, as it is called, and it landed on a church, and more than 70 people were killed. What happened there was warning to the government. The government knew that there was an ongoing situation there. Nobody did anything. But there were some historical complexities that there are some historical complexity that this community has suffered. It's a Black community, it has been impoverished, there are no public services. And after the massacre took place, the government committed itself to addressing those structural measures, those structural problems, and adopt structural measures to basically trying to deal or grapple with the underlying issues that make it possible for that massacre to happen. So I think that, and of course, there was also measures to compensate individual victims of the crimes. So I think reparation needs to be seen or perceived as multifaceted approach. You need to be able to address the structural causes for the violence not to happen in the future, but you also need to acknowledge that there are individuals or community who have been disproportionately impacted by that violence, and they also deserve to be not only recognized, but probably they deserve to get some specific form of reparation. So I don't think it's incompatible. Now, who pays for that? I think also there are multiple stakeholders that can participate in that. We need to see the history. Who has certain level of obligation to these individuals or these communities and has neglected them. You see, the government, there are historical causes, the government needs to chip in. There are some concrete cases where we see that perpetrator can compensate and have the means to compensate. They should also chip in with the economic resources they have sometimes collected throughout the armed conflict in the context of Colombia. So I think that there is not like a simple answer, but I think we need to put into context and we need to think about it like a multifaceted approach. It doesn't need to be one or another. It needs to be collected to some extent. It needs to be historical to some extent, and it also needs to be individual to some extent. So I think we should approach it that way. Thank you.
Thank you very much. The floor's still open. I am scrutinizing my screen. Yes, Lara. Well, should we have maybe Maria ask a question or make a comment first? Maria, go ahead.
Thank you. Thank you for the presentations. I joined a bit late, so I was only able to see the two from Colombia, but my question relates to that, actually. And specifically with Laura's intervention when she was talking about how ex-combatants need to be reintegrated within society. My question is, how do we also work, or what mechanisms you think we can envision to ensure there's no stigma associated with being ex-combatant, to combat also kind of some prejudices that society have against them, and fear and kind of like stereotypes, like wrong and bad stereotypes about ex-combatants, and kind of fuse that social link in order to achieve a true reintegration.
So I love your question, Maria, because actually one of the points of including ex-FARC within the reparation system is to also change the perception that we have as the evil ones, because you also know that lots of ex-combatants are also, or were also, victims of armed conflict, and that was sometimes one of the reasons that they joined the armed group. So there are lots of measures that have been put in place in order to erase that stigma, and that is basically through the acts of reconciliation and memory that the ex-combatants have introduced and proposed to do. Not only them, but also other institutions like the Truth Commission, also the Special Jurisdiction for Peace, and civil society in Colombia, you know, that is really strong in our country, and those acts of reconciliation are the key point, or are crucial in order to avoid and erase that stigma. So, for example, I have one example. On August 22 last year, and for 1 week, 80 artists from different disciplines, along with former guerrillas and victims of the conflict, came together in a festival called Caquetá se pinta de colores. Caquetá is painted in colors. And a cultural commitment, it was a cultural commitment to peace, reparation and reconciliation of this region, one of the hardest hit by violence. Caquetá was the epicenter of disputes between guerrilla groups and paramilitaries. And just to give you some numbers, in this region, one of the almost 400,000 inhabitants of that department, 360,000 were affected by the conflict. So the festival is a replica, actually, of an initiative that was born in one of the reintegration spaces of the FARC, where they are having or doing their incorporation process. And the idea was to start a dialogue with the communities where they are. They were interventions by people with their stories, artistic displays, were also built together with the population, and they decided to tell their stories and the geography of its territory. So I love your question, because that's one of the key points, not only to repair, but also to reincorporate. And also here is something good that we have to put on the table, is that not only the FARC is incorporating, but we are also incorporating to something new. So we have also to be part of those reconciliation acts and avoid that stigma. So I hope I answered your question. And just to I don't know if there's any more questions, but I just wanted to comment on what Yuri has said.
Go ahead, we're still waiting for other questions.
Okay, so I was just gonna say that your question, Professor Mégret, it relates not only to compensation as one of the type of measures of reparation, but it relates to the other measures, and also in their individual and collective dimension. Why? Because, for example, if we need to have a meeting, reconciliation meeting, or if we have to be in the hospital, well, we do need money, right? So this is a huge deal. But just to let you know that there is a fund that was creating to repair the victims victims of FARC members. The point is that, as I told you, the FARC at the beginning, they have submitted or delivered only 4% of what they told they had. So we have a huge problem here, because there's not enough money on that fund. And just to tell you that peer statistics says that we need more than 56 years in Colombia to compensate or able to repay the victims in our country. 56 years. And we already, we have been in this process for more than 10. So just to give you those all that information, and also the special jurisdiction for peace in Colombia, for example, they cannot impose monetary sanctions upon FARC members, but to the other ones they can, because of the creation of that fund. So they have to articulate with the administrative entities that are in charge of that reparation system that Yuri told you about. So yeah, I'm going to stop there.
I can maybe speak a little bit to these same questions from the perspective of Canada, on the question of who pays, how do we repair. I think there's two elements that are interesting to address here, and maybe to make some links or some distinctions with Colombia. So on the one hand, I think it's important to acknowledge that reparation will never be full, and in the guidelines and in the guiding principle and directives elaborated on reparation by the UN on reparations for gross violations of human rights, there's this inherent recognition that you can't, because of the nature of the violation, full reparation, which is usually when you think of reparation, you want to bring the victim back to the state it would have been if the injury had not occurred, right? That's kind of the underlying premise. But in the case of gross violation of human rights, well, on the one hand, that's not possible. And on the other hand, because of the number of victims, that's also maybe call for a distinctive way of thinking about reparation. And so I think it's important to keep that in mind when we think about, okay, who pays, who's responsible. And the other point, and it's related, is that in Canada, well, when you think of any kind of transitional justice process, or you think of kind of three categories of people: victims, the lines may be blurred, but victims, perpetrators, and bystanders, right? And in Colombia, from what we've heard, there's quite a high proportion of victims and a significant number of perpetrators, and then the rest of society as bystanders of the conflict, although these categories may have shifted over time because the conflict lasted for so long. But in Canada, we have a significantly small proportion of the population as a victim, right? Indigenous people do not constitute a big percentage of the overall Canadian population. And then a huge portion of bystanders. And yes, there are individual perpetrators that could potentially be named, but really the main perpetrator is really the state, right? And so when we talk about the responsibility of the state to provide reparation, it seems pretty straightforward. But then when you think through it, where does the money come from? It comes from this large pile of bystanders ultimately. And so it brings the question of why do non-Indigenous Canadian owe a duty to, or an obligation to provide reparation through the state to Indigenous people for actions that were committed by political elite or past generation, and this question is important because it brings us to the question of reconciliation, and reconciliation has been criticized for many things, the idea of reconciliation, but one of it is that it seems to be about Indigenous people reconciling themselves with the history and now let's move on, and not really engaging non-Indigenous Canadians. And so I think the question, like one important question when we think through reparation, because it's one thing to say, well, it's the state and it's all on the state, and then reparation, as Laura just said, it can be many things, and yes, compensation, and yes, it surely involves a lot of money, but it's also about many other things, like symbolic gesture of truth, recognition, and also, and most importantly, I think in the Canadian context, structural changes. So guarantees of non-repetition in the form of reform, which is not necessarily all about, dollars. So reparation as something that's multifaceted, that's not just about money, that I think, as we've discussed also in the Colombian context, there needs to be a balance between the individual measures and the collective measures, but also thinking at what role, what place is there for this very vast and vast proportion of the population that has been a bystander of settler colonialism, but that ultimately benefits from this system, right? Non-Indigenous Canadians benefit from the fact that the state just claimed sovereignty and land, and so how do we integrate that when we discuss about reconciliation? And I think this is where the idea of reparation is important and interesting. I'm going to stop here because I see there's a hand raised and there's not that many questions, that many time left, but there's much more to be said.
Castriela, do you want to ask a question? Go ahead.
Hi, everybody. Thank you so much for these really interesting conversations about reparations, not only in Canada, but also in Colombia. I'm from Colombia. Hi, Yuri. And I'm Afro-Colombian humanities and also a scholar. And I'm curious about the ways in which we can think about these particular frameworks of reparations in terms of historical reparations. Because as you know, in Canada and in Colombia, there are indigenous people, but also in our case, Black people, Black communities, and they are most victims of our conflict now, but they have been victims of social exclusion historically in the country. So I think that the frameworks of reparations that is on the systems, the old systems of transitional justice is good, but it's not enough. It's not enough because this kind of social, historical, structural exclusions that still exist in Colombia. So Laura was mentioned about colonialism and racism. Yuri mentions the case of Bojayá, but at the same time are the cases in Tumaco and Cauca, as well as the 42 massacres in the Montes de Marias in the Caribbean regions, my regions. And most of the people affected with this kind of violence has been Black and Indigenous peoples, as well as peasants people. So I wondered how colonialism and racism are, in your consideration, are not central components to think about the process of reparations in Colombia. How can the systems would address these particular historical issues in order to think about more than in restorative justice, in racial justice as well as for these particular communities? This is my concerns, and I would like to hear more about these particular issues. Is the time allow us from you, Yuri, Laura, and all the panelists, and thank you so much for this great conversation.
If I may claim a right to precedence here.
Sure, go ahead.
Castriela, good to see you. I know of your great work as a Colombian, as Afro-Colombian woman in the academia, so I'm really happy to have you here. And I mean, that's basically my dissertation about. That's what I'm working on my dissertation at McGill, to try to address that and basically to argue that the current system is not enough to address the reality of Black communities. But without anticipating, because I still need to do my research, but that's a true concern to Indigenous and Black community, because when we see it, 1.2 million of Black people have been victims of the armed conflict, which means we are around less than 5 million. That means more than 25% of Black people in Colombia. 1 out of 4 Black people in Colombia have been impacted by the armed conflict directly. I'm just talking here about people who have been impacted directly. Now, those who have been impacted indirectly will be like 50% or more. And that's on top of course, that's the direct impact that we see now, but there is a historical impact that has allowed for that to happen. Like, why would this armed group go to our territories? Why would they go to displaced people? Who would they claim those lands for? Development projects, agricultural industry to come to our territories. There are many intertwined issues there that are not isolated. The armed conflict didn't go to this territory just because a mere casualty. There is, I do believe there has been a concerted effort to uproot Black people from their territories to make it profitable for other people. And just the statistics, and I think many historians have documented this better than me. And that needs to be addressed. And as Castilla might know, in Colombia, there is a denial of racism, structural racism. So the debate, people are not, the institutions or the institutionality in Colombia is not willing to engage in this debate about racism. And that creates a challenge that we need to first acknowledge that there is a problem of racism, historical racism, and then grapple with the legacy of that racism. If we don't do that, we are not going to be able to address the structural problems that underlie the disproportionate impact not only of the armed conflict on Black community, but of poverty on Black community and Black territories. So I don't know if I'm answering your question, but I just think that there are more questions to ask than to answer. And I think we need to work towards that. And as I told you, that's part of my dissertation, basically. And let's see if I can find something that can be interesting. And yeah, that's all I would say. Thank you.
Thanks a lot, Yuri. And I see that the clock is ticking, and we've reached officially the end of what I think has been a very productive hour and a half. Quite a few times the notion that we have more questions to ask than answers to bring came up. So I think that's definitely a good start. I want to thank all our speakers and give them at least virtual round of applause. I see there's some little hands, digital hands appearing, and thank to all who could attend. On behalf of Nandini as well, we look forward to continuing these conversations with you in the future. Take care, everyone. Have a great weekend, whether it's snowy or not.